Hi everyone, my name is Gayani. I am an intellectual property attorney, actually a patent attorney in US, and I'm creating this series of videos to give some information about intellectual property for those people who are interested in starting a business or have started a business, and how to think about intellectual property, because I find with my clients there's a lot of questions. How does the patents works? How does the trademarks? So again, this is just educational purposes. If for more specific questions, you should consult with the qualified patent attorney if you're looking into patents or intellectual property. You want to talk to somebody who practices in that area that is qualified to talk about it. So when you're thinking about startup or a business, you want to think, what is is it a service oriented, or do you have a product or a process you're trying to put together, and how that going to be protected from with the intellectual property perspective. So to keep this video sort of short, and I will put out some other videos on each of these topics, I will just give you a little overview of how to think about these each of these topics. So you hear a lot about patents. So because I am a US attorney, patent attorney, I'm going to limit this discussion to US patent law. So the US patent law, basically you have several types of way to start with a patent. Patent would be, you will hear about a provisional, non-provisional. Non-provisional is the utility patents, or you will hear PCT, which is the international application you file and then decide to enter into the national stage later. So what can be patented? Patents can it had to be more than an idea. So your invention had to be something more. You have to be able to reduce it to practice. Now, reduce it to practice doesn't mean you had to have a model ready. You could have a constructive reduction to practice, meaning you have all the details worked out. So it could be a process, such as a business process or software. It could be a machine, article of manufacturer, or composition. Compositions are what you hear about, like pharmaceutical patents. So that's what usually you have it under, and you will hear like biology patents will have like different species that are genetically modified. You cannot patent something that is discoverable, that is in nature. If you discover a new bacteria, for instance, you cannot patent that, but you could patent probably the process you use if it's something new. So there are several ways to employ a patent for your business. You want to think about what is it that do you have something more than an idea, and you also want to think, is it something you want to patent, because patent become public because it get published after 18 months from filing. So that's the exclusive right you get. After patent is issued, you get an exclusive time frame to exclude others from using the same thing. It's not an affirmative right, actually, meaning just because you get a patent doesn't mean you have a legal right to use it in the sense if it harms somebody, but you have what you get is a legal right to prevent others from doing the same. Next topic is trade secrets. And trade secrets are something, if you hear about, I think most famous ones you hear all the time is the Coca-Cola recipe. So one thing to think about is if it's a process or something like the Coca-Cola recipe type of thing, you may not want to patent it, because when you patent something, that's become public knowledge. It's get published within 18 months of filing the patent, so filing the application. So you may want to protect it as a trade secret. Now, you can't just say it's a trade secret. There are certain procedures you need to do and trade secrets are, again, this is some what is relevant for United States. What I would say is you want to identify what's your trade secret, what part of your business is trade secret, because there are sometimes people will use patents to protect the composition of something, and the process would be trade secret. Of course, remember, look out for the patent video, because there are certain things you must disclose to get a patent, so there's sometimes you cannot split that. But with the trade secret, what you want to remember is a process that if somebody reverse engineers it, unless it's derived from your process and you could show it, it's hard to go after them. So but if it's something you think is a little difficult to reverse engineer, like if you have a process where you have different temperature settings, and those are really important for what you're getting out of the final product, you may want to keep that as the trade secrets. So trade secrets, you have to also show that you protect it as a secret. So that's mean limiting who have access to it, actually keeping a log of who have access, how you maintain it. So those are very important. You can't just claim it's a trade secret. You need to show that you have protected it as a trade secret. So that's something to think about. Next type of IP is trademarks. And if you think about Apple, Coca-Cola, Nike, just do it, you get the idea. It could be a phrase or a symbol that represent the goodwill of the brand or the company. So what you want is something that is distinctive and not descriptive. What I mean by that is, when you think about these marks I just mentioned, like Apple is not the fruit in this case, it's the computers, iPhones, iPads, and all these products, electronic products. And because of the distinctiveness, how different it is, it's create that when somebody say I have an iPhone, I have an Apple, you think about this electronics. So you want to think of a trademark as something that may not be descriptive of what you're doing, but something you could build into. More unique it is, the better it is. And with trademarks, another thing you want to think about is there's two ways to file a trademark in US. You could do intent to file. So when you have the mark, when you're using it, you should put a TM. And that's actually is because it shows that you either filed the application but haven't gotten issued the trademark, or you intend to file it. So if the mark is issued, you will see a R in the circle, and that's actually mean is an issued mark. And sometimes you will see next to the mark like SM. SM actually mean is a service mark. So those are the different symbols you see. Like I said before, I'm gonna put videos together for each of these topics separately. I'm gonna try to keep all these videos kind of short so you could use them, listen to them quickly. The next topic is copyright. And copyrights, I think you have seen the books. You will see copyrighted material, all rights reserved. Websites have copyright, and if you have a website, you should have copyright information on there. Your pictures, anything that is creative. So copyright actually protects the creative expression of original work fixated in a medium. So what does that mean? It if something is written down, you could copyright it. If it's recorded, it's copyrightable. So that's what this means to be tangible medium. And with copyrights, you don't again have to register it, but if you want to litigate it, if you want to bring a case against somebody, you do have to register it. Again, I will go more into this detail in a separate video, so look out for that. Okay, so that's a rundown on patents, trademark, trade secrets, and copyrights. Like I said, this is just beginning of the series. I'm gonna post some other videos specific to each of those and other topics. And meantime, just remember, this is for educational purposes only. If you have specific questions, please consult with a qualified patent attorney or trademark attorney if it's about trademarks. And if you would like to connect with me or ask a question, I will put down how to connect with me below under the description box. And if you like this video, please subscribe. I look forward to hearing your comments. Thank you.